Good evening, ladies and gentlemen, and welcome back to Legally Speaking. I want to thank you guys so much for joining me for part 2 of divorce proceedings, or as we call them, dissolution of marriage. Now, in last week's video, we touched on a number of things. We touched on the time frame within which you can present a petition for divorce. We touched on domicile. We touched on grounds of divorce. And I mentioned last week that there are matters that we call ancillary matters. These are ancillary to the divorce proceedings that must be dealt with before a divorce can be finalized. Before it's official, I'm divorced, I can go back to using my maiden name, I don't have to consider this person my spouse anymore, or worry about all of the other legal consequences of having a spouse, right? So, what are these ancillary matters? We mentioned specifically minor children under the age of 16, or if they're over 16, they are receiving instruction at an educational establishment or undergoing training for a trade, profession, or vocation, right? So satisfactory arrangements are going to have to be made in the best interest of these children, and before the court can make that decree absolute. Now, that's maintenance. Maintenance here can also be for a spouse, not just for minor children, but there's also spousal maintenance or alimony. Some of you might know it. And so there's that as well. In relation to the children, though, there's also the issue of legal custody. Being the child's primary caregiver, so the child might reside with you, spend most of the time with you. That's different from legal custody. Legal custody here refers mainly to decision-making power of the parents, right? So there's sole custody, there's joint custody. And so under a situation where there's joint custody, and this is possible where parents understand that, look, we have a child together, and no matter what happens between the both of us, this child is going to continue to be our child until, not until somebody dies. The child would always be a child, right? That's what it is. And we are going to be mature, responsible adults, and we are going to communicate with each other. Not that we are still talking on that level, but when it comes to our child, we understand that we have a child together, and we have a shared responsibility to raise that child, right? And so you guys continue to communicate on an amicable basis in the best interest of that child, right? That's the ideal arrangement. It's very unfortunate that it's not always possible, because parents sometimes, because of differences that exist between them, sever ties with their spouse or their child's father, child's mother, to the extent that they are not willing to communicate with that person at all, not even on matters relating to their child. Extremely unfortunate, but it happens, and it happens fairly regularly. Sometimes the court is constrained to make an order for sole custody. And so what are some of the decisions that I'm talking about? These are decisions that relates to the religion of the child. It relates to, like, say, what's the educational institution they attend. Sometimes the child might have to undergo medical procedures, whether emergency or otherwise, and might need the consent of a parent to make those decisions. Traveling with the child, migrating, that sort of thing. These are very important decisions that parents must make for children until they reach an age where they can make those decisions for themselves. And so having that custody of the child gives you the freedom to make those decisions, either, as I said before, by yourself, or in collaboration with the child's other parents, right? So you have legal custody, you have access, which is to say that the parent who does not have primary care and control of that child has a right to see that child and to spend time with that child. And so access must also be worked out before the divorce is finalized. Under what circumstances am I going to see my child? When? For how long? Whatever the case is. Typically, children, especially female children, tend to stay with their mother. And I must mention the fact that um, mothers don't have any right more than a father to a child. But, this is just the natural order of things, especially when they're very young, right? When the children are breastfeeding or, you know, 2, 3, 4 years old, still very young, children would naturally tend to be with their mother, right? But notwithstanding the fact that both parents have equal rights, um, children tend to be with their mother. And so what I come across most often is an arrangement where the father has access to those children on weekends. Might be every weekend, might be every other weekend, sometimes it's even less than that. Um, there's some parents who come to an arrangement where the child spends 1 week one place and another week one place. So the child bounces between mother and father, whatever the arrangement is, that must be worked out before that divorce is finalized, right? And so it's very important for parents to know and appreciate that you have a right to access to that child, right? And I won't get into to supervise access and liberal access and that sort of thing, but just keep in mind as a general principle that you have a right to access to the child, and those issues must be worked out before um, that divorce is made final. So you have custody, you have access, you have maintenance. That's the responsibility to maintain that child. And usually that is in the form of giving the parent who has primary care and control of the child such lump sum or monthly payments as the need arises um, for the maintenance of that child, right? And there's also property. Um, Property is kind of tricky because people assume that it's 50-50. So once you split, I take my half and you take your half. That's not always the case. The first step would obviously be to determine what property falls within the definition of matrimonial property. And you might be surprised that not all property actually falls within the ambit of matrimonial property. And so let's say, for instance, at the time that you met me, I already had my land and my house, and I acquired that property by a deed of gift from my parents. Um, Obviously, when it's time for a division to take place, it's not going to be 50-50, right? That's not going to be, even if 50-50 might be the general starting place, it's not in all circumstances, right? And so the court would take into consideration the contributions that you would have made, not just in terms of the financial contributions that you would have made to, say, like the repayment of a mortgage or in the actual acquisition of property, or renovations, um, taking care of the house, performing your spousal duties, raising children, cleaning, cooking, washing, all of these things give rise to an interest in property. And so I want to mention here specifically that if you are married to somebody, in circumstances where you are making a contribution to the mortgage, or you actually made a contribution towards the acquisition of that property, you want to ensure that your name is on the title deed. And I mentioned this specifically when we did our first series of videos. That's not to say that if your name is not on the deed that you are not entitled to anything, but if your name is there, it's going to make your life a lot easier. And there's legislation in place already that provides for a spouse to add their spouse's name to a title deed tax-free. So there's absolutely no reason, no excuse why your name should not be on a title deed. And I want to mention that here specifically because, we live here in the Caribbean, and there is a kind of tradition or custom where one party to the marriage has all the assets registered in their name only, usually the male. It's not a good practice, and you want to avoid that. If you're going to start an argument in your marriage, this would be a good argument to start, right? Ensuring that your assets are registered in both names, right? Especially in circumstances where you have contributed to the acquisition of or payment towards these assets. Right? Don't take it for granted. Don't allow the emotions and whatever to cloud your judgment in this regard, and don't allow anybody to make you feel that you are after material things when you have that right? And I want to be sensible about these things. So the rest of this video is just about explaining, what are some of the things that the court takes in mind when it is exercising its power under the Matrimonial Causes Act to make certain orders, whether it be property adjustment orders or orders for maintenance of a spouse or a minor child, right? I'm going to put them up on the screen here now. And so you have a look at them as I go through them, and those circumstances are the court is to have regard to all of the circumstances of the case, including the following matters. That is to say, the income, earning capacity, property, and other financial resources which each of the parties to the marriage has or is likely to have in the foreseeable future, the financial needs, obligations, and responsibilities which each of the parties to the marriage has or is likely to have in the foreseeable future, the standard of living enjoyed by the family before the breakdown of the marriage, the age of each party to the marriage and the duration of the marriage, any physical or mental disability of either of the parties to the marriage, the contribution made by each of the parties to the welfare of the family, including any contribution made by looking after the home or caring for the family, as I mentioned previously. In the case of proceedings for divorce or nullity of marriage, the value to either of the parties to the marriage of any benefit, for example, a pension, which by reason of the dissolution or annulment of the marriage, that party will lose the chance of acquiring. Now, when you look at these considerations, you would notice that there is the mention of void and annulment there. There's dissolution of marriage and there's also annulment of marriage, which is to say that the marriage was void from the very beginning. In this series, I will not cover that because, in my practice, I've never really come across that, and I am pretty certain that in most cases, marriages are legit in that they are not void or voidable based on, the provisions of the Marriage Act, right? And so because these are so rare, I don't mention them at all. So just to clarify what those terms mean. And so to exercise those powers as to place the parties so far as it is practicable and having regard to their conduct, just to do so in the financial position in which they would have been if the marriage had not broken down and each party had properly discharged his or her financial obligation and responsibilities towards the other. Now, where the court is exercising these powers in relation to a child of the family, the court is to have regard for the following matters. That is to say, the financial needs of the child, the income, earning capacity, if any, property and other financial resources of the child, any physical or mental disability of the child, the standard of living enjoyed by the family before the breakdown of the marriage, and the manner in which he was being and the manner in which the parties to the marriage expected him to be educated or trained, right? And to exercise those powers as to place the child so far as is practicable and having regard to the consideration mentioned in relation to the parties to the marriage, and to do so in a financial position in which the child would have been if the marriage had not broken down and each of those parties had properly discharged his or her financial obligations and responsibilities toward him. Right, so that is just to give you an idea as to some of the factors that the court takes into account when it is exercising its powers when it comes to these ancillary matters. The important thing for you to keep in mind here is that until these matters are dealt with, your divorce cannot be made final, right? And I will forever advocate for parties to resolve these matters by agreement and not put the court in a position where it has to make decisions on matters so important for you. You are best placed to make these decisions among yourselves. And so that is my encouragement. And so I end this part of the series here on this point. I know that the information that was presented in this week's video and last week's video should give you an idea as to what you should expect if you are filing for divorce, or what things you need to keep in mind if you are still deciding whether or not you should get divorced, right? So that's been it for this two-part series, and I trust that it was at least educational to you and you learned something that you didn't know before. All right, so that's been it. Do enjoy the rest of your evening and have a good week up ahead.